that tribe, we cannot go ahead and serve that person. If, however, let's say I'm living on tribal land, my wife is a registered member of that tribe, and I'm not, I can be served. Okay. My wife cannot be served because she must be served by the tribal police after what's called comity, COMITY, has been established, as opposed to comedy, but sometimes it's a bad comedy when all this is going down. When we serve corporations and other businesses, such as along the 101 corridor up in Scottsdale, if you look to the east, all that is tribal land. If you look to the west, that's city of Scottsdale. A lot of these businesses have located on tribal land thinking that they cannot be served. Cold Stone Creamery, I'll give you an example. I served them several times, and that was before they changed their statutory agent. I went in, I served Cold Stone Creamery, and they said, we can't be served. We're on tribal land. I said, are you a member of the tribe? And of course, they were dumbfounded because they're not a member of the tribe. They're not part of the tribal government. They're just a corporation that sits on tribal land. Therefore, they're not protected. But an individual who is a member of that tribe is federally protected from being served with outside process unless the tribal court grants the access to serve that person. Does that help? Does that make it clear as mud?
Yes.
Okay. You're welcome to give me a call anytime. I'll be happy to go ahead and walk you through it.
Okay, thank you.
Okay.
Okay. Another question, Christian?
Okay, can you hear me?
Yes.
Hey, Christian.
Yeah, okay. Hey, Barry. So, I just had a question on protection orders. Is there anything in the pipeline where we can still charge, or is it going to be just a dead subject with refusing to do them because we can't charge for them?
We can, orders of protection, process servers may not charge a fee for at all. And this is a thorn in our side because the constables are overwhelmed, the sheriffs are overwhelmed with these things, but the statute says that no fee shall be charged for service of process. It doesn't say no fee shall be charged for service of process by the sheriff or the constable. It just says no fee shall be charged. So that prevents process servers from charging a fee for service of process of an OP. For an injunction against harassment, if there was a criminal violation that's specified, such as molestation or something like that, again, we cannot go ahead and charge for service of that injunction against harassment. If it happens to be something like your neighbor's dog bit my dog, that kind of thing, yeah, we can charge for that. Yeah. But that's where we're at on protective orders until the statute gets changed, and the constables and the sheriffs and the judges and everybody involved pressures the legislature to go ahead and help the Arizona Process Servers Association, because we've already written the statute, but none of the legislators want to go ahead and take the bill to the floor. So that's where we're at.
Okay. All right. Thanks.
Don, I can't hear you. You're muted.
Sorry about that. Two more questions, and then we'll have to move on to the next presentation. The first question is, can you serve the Hague through the Hague Convention for Mexico and other countries? How could that be accomplished?
It's a complicated process, and it can go ahead and be done, but it has to be done very, very specifically. It has to be done under the treaty, And under Mexican law, there has to be a translation of the document into the native language of whatever that country may be, whether it's Mexico or France or whatever it may be. And it's pretty complicated. There are very few companies that serve in Mexico or other countries. If you need to go ahead and get some additional information or additional help, give me a call. I'll be happy to go ahead and answer any questions I can or give you a referral.
Okay, and then the last question is directly relevant to stat agents. So as a statutory agent, once we submit a resignation to the state, there is often a delay before the state updates its website to reflect our resignation. During this period, at what point do we have the legal right to refuse service of process or other official documents on behalf of the company? And does that resignation become effective upon submission, upon acceptance by the state, or only once the state updates its records?
The resignation is effective upon acceptance by the Corporation Commission. It is not effective upon when you sign the document and send it in, because you may sign it today and it may not get accepted and posted until, let's say, 2 or 3 weeks later. In fact, I served a paper yesterday on a gentleman who's a CPA and he's a statutory agent for someone. And the statutory agent said, "Hey, wait a minute, I resigned as a statutory agent this morning." I said, "Well, guess what? You're still on the Corporation Commission's records. Here you go. Tag, you're it." So, yeah, he had to accept the papers, and that was it.
Okay. All right. Well, again, Barry, thank you so much. That was a great presentation. Everybody, I will be forwarding his presentation, which has his contact information on there. If you need to contact Barry about a serve or just questions about today, I encourage you to do that. And Barry, we can't wait to have you back another time. We appreciate all your knowledge.
Thanks. Maybe next time I'll talk about enforcing judgments.
That's actually that's okay. I'll have to call you. That's why I asked you about the electronic adoption in other jurisdictions. So another day. So all right,
Okay.
thank you. And so now we are going to move on to the third of four presentations where we're going to talk about living trust basics. And so while we get that set up, I'm going to share our second verification word, which is brave. Hopefully everybody can see that. I've shared the screen. Brave, B-R-A-V-E. Be sure and write down the second of the three, what will be three verification words. And you'll email those to me at the end of the conference, of the webinar, and I'll respond with your the certificate of completion, as well as the handouts that we have for the class. So brave is it. And then, so write that down. And John, I'm going to spotlight you. There he is. And then everybody have that down. Hopefully nobody's taking a little break. Okay. So, we're going to have a little condensed presentation for this part of it, but that's okay. It's not a long one. But let me get that up here and we'll get started. So, all right. So we're going to talk about living trust basics. And this is a presentation I'm doing with John Kroger. John, welcome. Thank you for agreeing to come back with all your knowledge about living trust, to help educate us all. So the idea behind this presentation, it is a living trust basics. So I'm hoping maybe some of you out there that either don't have a lot of experience doing living trust, or maybe just are considering getting into that end of the business. Our objectives here are to give some good solid basic information so you can maybe transition into that type of work if you wanted to, or maybe just for, your clients to give them some important information so they can get that kind of work done, whether it's through you or someone else. So, all right, so we'll dive right into this. Uh, the agenda for this segment is we're going to talk about living trust fundamentals. So fundamentals meaning kind of where the authority in Arizona comes from to form living trust. What are some of the requirements that you have to have in every trust, or rules about trust? What are the key components of a living trust? We'll talk a little bit about funding a trust as well, maintaining a living trust. And then we're going to get into more of a focus on how we gather information from people so we can prepare a trust that they want. So determining the customer's needs and some ways of information gathering. Again, throughout this process, even though we're going to condense it a little bit, we welcome your questions or your expertise. I'm sure there are many people in attendance that this is their expertise. So if you see something to add, please, by all means, do so. And even though I'm presenting, I will try to recognize it in the chat or if you have your hand up. All right, so let's move forward. So beginning with living trust fundamentals, we're going to talk about statutory requirements and then the key components or provisions of a living trust. And I'm going to ask John to kind of start this particular area about requirements for creation, where that comes from, where it is in the Arizona revised statutes, and I'll hand that over to John. Go ahead, John.
All right. First question is, can you hear me? I don't have my
Yep.
I don't have my microphone piece, but can you hear me okay?
We can hear you great.
All right, terrific. Yeah, like Don said, this is kind of intended to be like a 10,000-foot generic overview, and but if you have some questions and you want to get into some specifics or questions, why, we'll do our best to answer it, and then we're hoping that other members of the audience can step in and back us up where maybe we don't know. And kind of like all areas of human life, it seems like the law gets involved in writing about it, and trusts are no different. A trust really is nothing more than one person giving property to another person for a specific purpose. In other words, trusting them to carry out that purpose. So if Don were to stop by my office and say, hey, I'm going to go grab a bite to eat, and I hand him $5 and I say, hey, bring me a hamburger back on your way back, will you? That is a trust. It's an oral trust. And there are three things that are required to be a trust. The first is that I have to have the capacity to give him the property. And when I give it to him, I am what's known as the trustor, or in other terms, the settlor. That means I settled the trust into existence, or I'm the one that trusted somebody else. And when I give him the $5, as soon as he takes it, he now becomes my trustee. He's in charge of my $5, and I gave him instructions on what to do with it, which is to grab me a hamburger on your way back. And he's obligated under Arizona law to do that. That's in the trust code that says now he's obligated to follow those instructions. And the beneficiary of the trust is me, because I give him the $5 to spend what? For my benefit. And so that's kind of what this slide says. A trust is created when the following are true. The settlor has the capacity to create a trust. Settlor indicates his intention. And the trust has a definite beneficiary, which in our example here would be me, or it's a charitable trust, or it's a trust for the care of an animal, or it's a trust for a non-charitable purpose. And I wanted to delve into that a little bit. A trust has to have a beneficiary for a trust agreement to be valid. For that when I give Don $5, the difference between it being a gift to him or me giving him that property to be held in trust is there has to be a beneficiary. And in this example, I'm the beneficiary because I'm going to receive the hamburger. And then you go to the statute to see what a definition of beneficiary is, and a beneficiary has to be a person, so identifiable person. However, a couple of it says here the trust is for a definite beneficiary, which is a person, or a charitable trust. So I could give Don the $5 and I could say, hey, on your way to mass, will you drop that in the collection plate? And thus that's a charitable trust. I'm the settlor, he's the trustee, and there's a duty for him to perform, and the beneficiary in this case is the charity. Arizona does now allow a trust for the care of an animal. So I can say, Don, here's $1,000, take care of my horse or my dog or whatever for extended period of time. Or I can say, hey, if I die, here's some money and you're to use it for the care of that animal or for a non-charitable purpose. And that seems like kind of a catch-all, but it has to be some identifiable purpose. So, for example, I could give Don money and say, I want you to use this to campaign for the local school board. And thus, once again, I'm the settlor. He becomes the trustee. There's a definite purpose for which the money can be spent, and that's allowable. And then the trustee has to have duties to perform, as it says. And then it says, and this is something that I thought might cause some confusion, the same person is not the sole trustee and the sole beneficiary. So I can't say, oh, Don, here's $5, go buy yourself a hamburger. That's not a trust because he's both the trustee and the sole beneficiary. And so thus what it has become is simply a gift. On the other hand, if I say, Don, here's $5, buy yourself a hamburger, but if you're not hungry, I want you to buy one for your wife. Well, now all of a sudden, it becomes a trust because the terms of the trust are to buy a hamburger for first Don, and if that doesn't pan out, then secondly his wife. So that's what changes the character from a gift to a trust. And when we write and trust agreements, for something like here's $5, go get me a hamburger, nobody feels the need to write up a trust agreement. But if on the other hand, I were to hand on the title to my house and the title to my car and the title to my bank account and say, here, Don, I want you to take care of these things for me. And then after my death, I want you to take care of those things for my wife. That's something different, and it might be imprudent for me to hand over that title to the house and the title to the car and the title to the bank account without a written agreement. And that's where we as document preparers come into existence, is that we're the ones who prepare that written agreement between the settlor, or the trustor, as they're often called, and the trustee, that, hey, you're going to hold this property for me and do the same thing. Most of the time when we write standard trusts, though, we write the trust where the settlor identifies himself as the trustee and then also identifies himself as the beneficiary. And so you might look at this statement and say, well, wait a minute, isn't that contravention to Arizona law? And the answer is, in most of those cases, we also identify a successor trustee and/or we identify a successor beneficiary. So, hey, I'm going to retitle this property to myself as trustee, and I'm going to manage it for my benefit. But if something happens to me, I can identify a successor trustee. Now that's valid. And/or I can identify a successor beneficiary after my death, then my wife steps into the place of beneficiary, etc. So don't get tripped up on that statement, I guess is what I'm trying to say.
So
And
if
go
you,
ahead, Don.
no, I just wanted to add that if you're dealing with hamburgers and $5 bills, that's pretty much all you need to know. That's a joke. Anyway, go ahead. Thank you for
I'll
laughing.
repay you
Gary.
on Tuesday for a hamburger today, Don.
Yes.
Oh, that's a promissory note. I'm sorry. Um, but when we're dealing with substantial property, kind of like Nicole was talking about in an earlier presentation for conservatorship, that's where it might make sense to, not might, does absolutely, in my estimation, make sense to have a written agreement to determine, why this is being done, who it's being done for, what the trustees' obligations and duties are, and what's expected, not only immediately, but far into the future, because in most of these cases, a trust is intended to last a long time. And so that last slide that we were just on discussed a little bit about a beneficiary. And the point that I wanted to make there was that a beneficiary can be ascertained in the future. Well, if I die, then my children become the beneficiary. That means they're not the beneficiary now, but they're still considered a definite beneficiary if they can be ascertained in the future. Okay. And then finally, a power in the trustee or someone else to select beneficiaries is also valid. And where that comes into play is that, we're going to set up a trust. It's going to be for the benefit of me and my wife. And if I die, then it's for the benefit of my wife. And if my wife dies, I'm going to allow her to tell the trustee who the future beneficiaries are going to be, so long as you create like a class of people out of our children, or out of her children, or out of my brother's children, or out of the members of my fraternity house, or whatever, so long as it can be ascertained that a beneficiary is going to come from there. I don't have to specifically name those future beneficiaries. I can grant the authority to someone else to name them, and that frequently occurs. Okay. Any questions on that so far?
Nope.
Okay. So how is a trust created? Well, as I said, it could be oral, and that's number two. That's just simply a declaration, although we, as document preparers, would prefer to put that declaration in writing, and that's going to be our job. Number one is, a trust is nothing more than, even if we write up a trust agreement, nothing has happened until property actually gets transferred. And that's the part that really gets me. And I would caution anybody engaged in the business of writing trust agreements is that that's nothing more than a proposed piece of paper until, in fact, property is transferred. And I've seen some very sad cases where, and in most cases that come out of law firms, they don't go to the trouble to transfer any property. They just write up a nice trust agreement, charge several $1,000. People go home, put it on their shelf. They think they're all done. Somebody dies, and guess what? Property was never transferred. Therefore, that trust agreement wasn't really an agreement at all. It was just a proposal. And so actually transferring the property is really key to making a trust agreement effective. All right.
So in other words, the trust can only deal with what it owns.
That's correct. If property hasn't been transferred into the name of the trust, it ain't there. And somebody's last will can transfer property into a trust, so it can get transferred that way. Property can get transferred via a beneficiary designation. So, for example, 401k at work has a beneficiary designation. I'm not suggesting one do this necessarily, but that 401k dollar amount could be transferred to the trust via the beneficiary designation when somebody dies, et cetera. So that's kind of what number one is. Number two is simply a declaration that the property is trust property, and we'd like to see that in writing. Number three is exercise of a power of appointment in favor of a trustee. What those words mean is that if I die and in my will I have said my wife has the power to appoint my property to our children in whatever shares she feels. So she doesn't have to give it to them equally. She can give one 25% and one of them 50% and the third one the other 25%. If I give her that power, that's called a power of appointment. And if I say you have the ability to put it in trust, well, then that person can put it in trust. So that's how the trusts are created. All right, Don, we'll go on to the next one. Arizona's got a whole long list of statutes. It's in Title 14, Chapter 11. Even though you'll look on there and it says Arizona Revised Statutes Title 14-10. It's really Chapter 11, but the numbers they've given it are all tens.
I will fix that when I send out the.
No, that's correct. You have the correct numbers. It's just that it so happens that grouping of numbers shows up in Chapter 11. And in there is all kinds of stuff that a document preparer can read in preparation for writing a trust document. You might look at what the Arizona statute has to say and determine how much you wish to put into the trust document. You can talk about it. Certainly, you should put the duties, powers of the trustee and how successor trustees are appointed and who they are, how a trustee resigns, what they're supposed to do. Most certainly, if there's potential conflicts of interest, an example of a conflict of interest would be similar to what you might see in a financial power of attorney. You know, if I name my child as the trustee of my trust, a fiduciary obligation of a trustee is to act only in the interest of the beneficiary. And if I'm still alive and I'm still the beneficiary of my trust, that means my child cannot manage that money for any purpose other than for my direct benefit. Well, what if I want to give money to the church, charitable? My child would be prohibited from doing that without some express instruction from me. What if I wanted my child to be able to, who was acting as my trustee, to also pay themselves a birthday gift or pay for some of their education? Well, they would be prohibited under Arizona law, which is that number 2, conflicts of interest with a trustee, unless I specifically chose to override that and write that into the trust. And these are the kinds of things that we as document preparers need to be prepared to do. And in the end of this presentation, where Don talks a lot about fact-finding in preparation for writing a trust agreement, these are the kinds of things you want to look for and find out where you might need to put language into somebody's trust document to handle what their intents are. If there's more than one trustee, what is the relation between them? Do they have the authority to delegate tasks, or do they all have to agree on everything, or can they operate independently, et cetera, and so on and so forth. And of course, rights and interests of a beneficiary. A perfect example of a right of a beneficiary. And remember, the definition of a beneficiary is somebody who is either a present beneficiary or who might be a future beneficiary who can still be ascertained. So even though I might create a trust and name myself as the beneficiary right away, And then if I die, my children become the contingent or the subsequent beneficiaries. Why, they're still by definition a beneficiary, and the state of Arizona says they've got a right to demand an accounting and all kinds of other information regarding the trust. And that might be something that I don't want to give them. So that might be something that might be drafted into my trust that, hey, so long as I am the beneficiary of the trust and it hasn't devolved to the successor beneficiaries, well, then nobody can demand an accounting or something along those lines. So these are some of the nuance that you can run into when drafting a trust.
John,
Yes, sir.
Just a little comment. I think that clients as well as document preparers that don't do this type of work, at least not yet, can often be a little overwhelmed by the volume of information that goes into a trust agreement. And what I often will say to people, and I know this isn't, and isn't 100% comparable, but I often say to people, it's kind of like any entity that you would form. You would have bylaws with a corporation, you would have an operating agreement with an LLC, and you have those just like with a living trust agreement, because something's got to say you're creating this entity that is the trust, and something's going to say who the people are, what they can do, what they can't do. And so, most of it is filled with things that we know we can do in our daily life with our stuff already, but it's got to restate that because we're putting in the name of the trust. And it's got to have other provisions that, give us authority to put it in and out of the trust, to manage the trust, to enter into agreements on behalf of the trust, so on and so on. And so it's, even though it looks like it is a voluminous document, but the contents are pretty logical.
Yeah, I agree. I think that's very well said, Don. And the idea here with this overview is to kind of let our audience know what a trust is and what some of the considerations are going to be when we as document preparers draft these trust agreements on behalf of our clients. All right, and here's something that's real important, and that's that first sentence. The terms of the trust prevail over any other provision of this chapter, except you still, in order for a trust document or a trust, in order for a trust to be valid, the requirements have to be met. 2, the duty of the trustee is to act in good faith and in accordance with the purposes of the trust. So that I can't write a trust document that says, oh, and the trustee can do whatever they want, even if it's against what I originally wanted. I mean, that's kind of silly, but that's it. The terms of the trust have to say that it's for the benefit of its beneficiaries. And remember, that definition of beneficiaries has kind of been expanded. Beneficiaries isn't just a natural human person. It is, and that's incidentally a natural human person is, as opposed to say a corporation. But we've also seen in an earlier slide where it could include a trust for the benefit of a beneficiary. Could be a pet beneficiary, could be a charity, or a beneficiary could be for some other specifically defined lawful purpose. So we understand that. And that's what the rest of the sentence says, that the purpose is lawful and not contrary to public policy. So, for example, I can't give Don $5 and say, no, Don, I'm going to give you $10. I want you to get me a hamburger for $5. And on the way there, I want you to stop at my neighbor's house and beat up his kid because I really hate the kid. I can't say that because that's not a lawful purpose, and so thus the trust itself would not be valid if we attempted to establish an unlawful purpose. And then there's several times when when the purpose of the trust or the powers within the trust or even the beneficiaries are not perfectly clear, and the court reserves for itself the power to modify or even terminate a trust. And Don's listed a number of the statute sections here that allow that. Also, a trust can have a spendthrift provision that says, yeah, I'd like my kids to be the successor beneficiaries to this trust, but I don't want the trustee, I don't want them to have the ability to demand that the trustee give them money for whatever they want. I'm going to give the trustee the authority to not give them the money, which would include not give them the income out of it or not give them money if they're behaving in some sort of an irresponsible manner. And that furthermore goes to the right of creditors to reach the trust. A lot of people in the general public are confused, and they think that if they set up a trust, then they have just shielded their assets from a creditor. If I set up a trust and I'm the settler of the trust, and I reserve the right to change the terms of the trust, which includes to revoke it, then my creditors, I can't shield my assets by putting them into that trust. My creditors can still come after me. However, if I name my spouse or my children as contingent or subsequent beneficiaries of the trust, so long as the property remains in the trust, it's still my property. So long as it hasn't been distributed, my wife's creditors or my children's creditors can't get at it. I think the perfect example here was our former governor, Fife Symington. When he was doing property development, he was the beneficiary of his mother's trust, and it was a rather large trust, as in large. And he told his creditors, "Oh, don't worry about it. If this project goes belly up, I have this trust to back me up." And they took him at his word. And then when the project went belly up, they said, "Hey, we want to be paid, get into the trust." And the trustee turned around and said, "No, that's not Mr. Symington's money. That was his mother's money, and it's held in trust, and no, you don't have a right to it." And we had all kinds of lawsuits. The creditors lost. So then the attorney generals got involved, and they said, "Mr. Symington, we think you misrepresented your power over this trust, and so for loan fraud, we're going to put you in jail." And they did. And that was for a governor. But the point being that except for my own creditors, any other beneficiaries' creditors can't get at this thing. And that's kind of nice. Again, the court reserves for itself the power to dispense with or modify or terminate bonds associated with a trust, particularly if a trustee is asked to post a bond. And one thing is that under Arizona law, acting trustee is allowed to be compensated for their time. And even if the trust says they shall not be compensated, the court has the power to it reserves for the power in that section 14-10708. They reserve the power to override that and say, yeah, you can be compensated. So just kind of keep that in mind. Thank you. Next. How are we doing, Don? Are we doing all right?
We're doing as well as we can.
Nobody has any questions so far?
Actually, there is one couple things in here. Michelle asked if a consumer has 3 adult children, but one of those children are a step or adopted child, can you omit or withhold any beneficiary designation be left to that child? And I would say yes.
I'm sorry, I truly did not understand the question.
All right, let me try to, okay. If a consumer has 3 adult children, but one of those children are a step or adopted child, can you omit or withhold any beneficiary designation and be left to that child? I would say you could omit it for sure.
Well, yeah. Remember, a trust is for any reason that you want it to be, so long as the reason is not illegal. And so if you set up a trust and you want to name beneficiaries, you can name whoever you want, so that you're not under any obligation to name your children as beneficiaries, nor all of them, regardless of their status, whether they're a stepchild or whether they're adopted or whether they're your natural child. The trust is for whoever you choose it to be for. By the same token, you can choose the beneficiary to be a stepchild, even though they're not an official bloodline child of yours, or even though they're not officially adopted. You can still choose that. The danger perhaps comes for the document preparer in not knowing whether those relationships exist. And that's where the addressing the questionnaire and the fact finding is so important. The danger for the document preparer is to use real simple language that says, oh, at my death, my children become the beneficiaries, without going the extra step to define what the word children means. Does that mean bloodline only? Does it mean bloodline plus officially adopted? Do you intend it to mean stepchildren, your spouse's children from a prior marriage, for example? And if you do, then I think that's incumbent on the document preparer to make that clear. So I think that's a great question in terms of a cautionary question, but in terms of guidelines, there are no guidelines. You can write the trust for whomever you wish, but make sure you're clear about it when you draft it for someone.
And I would say too, in my experience, that the templates that I see out there, or the limited software programs, they actually deal with that issue. They may be more inclusive than people want, and so a client may need to watch out for that. But in my experience, like the FOR program that people have used for years, it definitely addresses those issues.
Yeah. There's a whole list of kind of other things in here, and something I wanted to look at was number 9 there real quickly, the effect of exculpatory term. What that means is that you can't relieve the trustee of all liability no matter what they do. So if I give Don $5 to go buy a hamburger, and on the way he stops and buys a joint and smokes it, I can't write into my trust agreement that, oh, if you misspend my money, it's okay. No one can sue you. You can't do that. The trustee has to act in a fiduciary capacity. Probably the only limited exception to that is that a successor trustee, you can have an exculpatory term that says that a successor trustee does not bear any responsibility for the actions of a former trustee. But that's about as far, I think, as you can go in that. All right, let's try to move on, because I know we got a bunch more slides here.
Yeah.
And Don, jump in anytime. Don't let me run away with this.
No, and so this next set of few slides, deals with. I mean, I've kind of looked at a few templates and taken these headings from the various templates that you're going to see usually in trust templates. I keep saying templates. So just recitals and conveyances. These are things that John just talked about that probably should be in trusts. Expressing the intent of the trust, the funding statement, in acknowledgement by the trustee of receipt of the trust estate. And, in the beginning, that, as it says there, it might be $10, it's a nominal amount that's contributed. But and then just going through the name, family information, successor trustee information, trust estate. And again, a lot of these things are going to look familiar. You're going to see these in operating agreements. You're going to see these in contracts. A lot of these, because it is a contract. A contract between, the client and him or herself. I think a good trust is going to have certain clauses in here about no contest provisions, special distribution sections. You may see some variations of those where it's there to protect really the beneficiary to some extent. So if you have a beneficiary that's underage at the time that the trustor dies, if you have a beneficiary that has a substance abuse issue, or is a special needs person, is on some government aid and receiving an inheritance would disqualify them from government aid. Some of these provisions that are in there just kind of address those issues should they be present. So to protect the beneficiary as well as the estate. Any other comments on this stuff, John?
Yeah, I think you alluded to it without directly saying it. I think I see most trusts written, if for lack of a better term, as kind of a will substitute, because rather than give property directly to my heirs, I'm going to give it to a trustee to hold and manage it according to my instructions. So rather than just an immediate gift to my heirs, I'm going to put the property in trust for the benefit of my heirs, who I'm going to name as the beneficiaries. And that's where a lot of this language comes into play. We don't distribute property to a 10-year-old, for example. So what do? Well, we give it to someone to manage for their benefit. We either wait for Nicole to file a conservatorship for that kid, or we give it to the trustee now and we write it up ourselves right now so that we don't have to fool with that. And that could come into play, particularly with a special needs trust, where we might have a child. Most commonly, it's a child. Somebody's child is a special needs child. They're never really going to be able to fully take care of themselves. So we're never really going to just give them property. We're gonna give it to a trustee to manage on their behalf, very similar to what a conservator would do. And we might even go further with special language in the trust that never gives that special needs child a legal right to the trust, thus enabling them to become qualified for state aid or government programs, for which, if they had legal control of the property or legal right to the property, they might not qualify. So that way we can conserve this inheritance, if you will, by never actually giving it to them, by segregating it. And that requires special language. But that's kind of what all of this is about, is to control the property rather than de facto gift it to your heirs, is to control it for a period of time. In some cases, it's nothing. Dad, go ahead and distribute it all right now. But in other cases, it's no, we would like to have this controlled for a period of time. And
I think provisions like this also speak to the necessity of having somebody that is your successor trustee that is, level-headed and reasonable, and not someone that's likely to take advantage of certain situations that may deprive a beneficiary from, part or all of their inheritance for a time. Because they give them a lot of power, although I love these provisions, I think they're necessary. But like, for example, if you have somebody that has a substance abuse issue, I've seen some pretty some provisions that deal with those contingencies that give the beneficiary a lot of hoops to jump through to kind of prove that they're, of sound mind and fit to accept their inheritance. And so it is something to look at carefully, because not, especially if you have a successor trustee that doesn't really like this beneficiary, they could make their life a little hellish. But a couple of questions that are in the chat. One of them is, what liability does the CLDP have if a client lies about their having or not having children? And I'll give my take, John, and then you give yours. I mean, I would say this is a reason that you have people fill out questionnaires, that you make disclosures, and that you have people sign approval documents indicating that they have read the documents and they approve them the way they are. So you can show that you're not part of that, conspiracy or whatever you want to call it, to potentially deprive that child from a portion of what otherwise may have been their inheritance. I don't know, but I certainly have had people that they didn't lie about it. They told me they had other children, but they did not. What happens sometimes is you have people that are afraid to mention that they have a child that they have no relationship with, that they don't want to get anything. They're afraid if they mention them that they're somehow going to be able to circumvent the intent of the will or the trust. And so sometimes you'll have some significant resistance to being, disclosing that. I don't know what your experience is, John, with that, but I've had that happen several times.
Yeah, and I think that's, again, it's part of the fact finding and getting to know your client. I had a client who was a well-known musician. I imagine every single person in this class would know them, or would certainly recognize the music. And I think that he knew of children by about 9 different women, but he didn't know who they all were, and new ones kept showing up saying, "Oh, I'm your child." I mean, and so we had to make sure we felt it prudent to put language in there to directly address that we were providing for only these named children with whom he had a relationship, that those were the beneficiaries of the trust, that this was not a catch-all that was supposed to grab all of his children, because new ones kept coming out of the woodwork. I mean, it's not funny, but it's true. It was an actual client of mine. So kind of fascinating in that sense. There's another question in there about creating an irrevocable trust. And yes, an irrevocable trust, as long as the language makes clear that it's irrevocable, there's nothing special that you have to do other than to make sure that's clear. And the inverse is also true. If a trust is really revocable, meaning that it can be changed by the settlor, that language probably ought to be in there so that there's no confusion. So direct language like that, I think, is good. Somebody else, and Don, you can handle this, was asking about software. There are a lot of different software programs out there that provide templates for this, for sure. I did mine out of what is the old Thomson West. I don't know who absorbed Thomson West, but I've since rewritten and have all my own templates. But that's where I had started from. And I know we'd had somebody that was soliciting into this group. It was called FORE, Trust Software. And Don, you may be aware of some others to answer that question.
Well, yeah, I used for many years. I've used some other more customized packages that some people had. But 4 was 4 is now Adapt, and they're a cloud-based program now. It's not it's not an app that you download to your just to have on your computer. And the templates are almost very, very similar, if not almost exactly the same as that were in the 4 program. But I have personally used it, given it a try, and I've had a few other people give it a try. In fact, we had the owner of the company speak at one of our webinars last year, and he's a nice, very smart guy, knowledgeable guy. There have been a lot of I've had people tell me they've had a lot of technical difficulties with it, and I'm aware of at least one company that stopped using it because of that. I really want to use it because I loved the 4 program, but I'm holding off, and I'm hoping that they eventually get these bugs worked out. But some of them are pretty significant bugs in my view. I don't want to badmouth the company. They have a great product. They always have, but there are these technical things that just can end up have you spending a lot of time fixing them. Footers and different things like that just are a mess. I haven't looked at it in a few months, and so maybe some of these things are fixed. So I don't want to say not to use it, but I am looking around at some other opportunities or options, and I hope maybe either if it be next month or in April to come back and say, and maybe even have one of these other companies present to give people some options. But right now, I don't have any options for you, unfortunately, not yet. So,
Don,
go ahead.
I'd like to go back and flesh out my answer to Jojo on the irrevocable trust.
Okay.
The direct question was, is this language sufficient? And yes, I believe that it probably is. But I also, for the sake of other listeners, want to say that I have never been a fan of most irrevocable trusts while the settler is alive, simply because my experience, and this is just my experience, has been that people want to create an irrevocable trust because they want to hide assets from creditors or from a spouse who is contemplating divorce. So they throw all this stuff into a irrevocable trust, saying it's irrevocable, therefore creditors can't reach it. Well, the sad experience is that then the settler can't reach it either, and in my experience, they always want to. So I've had to refer people to attorneys to take the case to court to try to break the trust, because they do things like stick their house in trust and stick their cars in trust, and these things don't last. They get sold, or you want to make changes, or I stuck my house in an irrevocable trust, creditor can't get at it. Now I want to do a addition to the house, and I can't sign the contract. It just, I find it to be very problematic in most cases, and I guess that's all I wanted to say.
I've had many people have issues with trust that some of which had them set up many, many years ago, and they are just stuck. They cannot do what they want to do.
Yeah, and I'm not a fan of the trust to try to hide assets, or I'm not a fan of even working in. Anytime it becomes clear to me that's what somebody's trying to do, I don't think they're a good client for me. I'll send them to an attorney. That's just all I have to say.
No, I'm the same way. So, all right. So we need to move through. We need to move through some of these things. I'm going to send this out. This just has really kind of a list of all the different provisions you're going to see in there, all these things about, again, it's kind of like I mentioned before, it's just kind of saying all the things that the trustee can do, what they can't do, when the trust becomes, what retained powers the trustors have to modify the trust, revoke the trust, when it becomes irrevocable, which and under what circumstances, and that depends what kind of trust it is, which we're not going to get into today, really. But I want to work down now to spend the last few minutes on this to just kind of talk about information gathering. And so, information gathering, I think has a couple parts to it. Certainly it has, a part which is probably mostly verbal, well, I don't know about mostly verbal, but it's partially verbal in communicating with the customer to find out what their needs are. And then in some way, either through interviewing or using a questionnaire, gathering the variable information that you need to prepare all the documents. And I'm going to briefly go over in a little bit a questionnaire that I have used. It's kind of basic. That can be more complex or less complex. But as far as determining the customer's needs, it's my practice typically, regardless of what the customer says to me at the beginning. You might have a customer that calls you that says, yeah, I need to do some estate planning, but I'm not sure what to do. Or I want to do a trust. My neighbor did a trust. My mother has a trust. Or I want to do a will. I only want a will. And I only want this to be in the will. I only want my oldest of my 7 children to be in control of everything. And I trust that he or she will distribute things. And so regardless of what the initial need is that is expressed, I will always do kind of an overview of what happens, if you have nothing, and then kind of work my way towards the way a trust can work for people. So, so I'll speak in generality about, if somebody dies and has no estate planning done whatsoever, this is what can happen. And again, talk in generality. In other words, I take the time to educate the client, so the client can best instruct me what they want to do, because often what they have in their mind isn't really a good idea or maybe the best approach to things, but it's not my place to advise them on what to do, but it certainly is my place to educate them about probate process, probate law, probate procedures, beneficiary designations, what they're all about, what a will might do for people, why people want to have any estate planning at all, and then what the differences between having a will versus a living trust might be in an estate plan for the average person. And I find by educating them in that way, I'm not stuck in a place where someone's asking me to do something that's really kind of ridiculous, or just not in their best interests, or just has tax issues associated with whatever they want to do, or just problems because somebody might die, and then the other people they really want to get things aren't going to get them. I feel that it makes it clear to people, what maybe would work best for them. So that's part of it. The other part is an initial determination of what the client's estate consists of, cars, bank accounts, retirement plans, insurance policies, personal property assets. I could go on, but kind of finding out what that is, and also eliciting and understanding whatever special circumstances that they may have. And so I'm going to get some of this information just by talking to them. It might be as simple as, tell me about your family. Tell me about your family, about your wife, about your children. What are they doing? Where are they at? Do you have grandchildren? How are your relationships with all these people? And that may seem forward, and maybe it's inappropriate in some circumstances to get, that personal with people, but they're asking you to do something that is monumentally personal to them. And so it's usually appropriate to go there. So, having those conversations with people, I think, can avoid a lot of problems and avoid putting you as the document preparer into a position where you just kind of know that this is not a good idea. I don't know if you have anything to add to that, John?
Yeah, I mean, that's imperative. I had a prospective client come into my office earlier this week, and he was referred to me because he was frustrated and with his estate plan, and he'd actually just had this plan drawn up by a law firm. Um, and they just did a boilerplate type of a thing, and I don't think anybody ever went to this. And this is an ethics issue too, in my opinion. I don't think they ever went to the trouble to find out, uh, because he wanted to give a bunch of his estate to charity. He had no children of his own, and he wanted to give a bunch of his estate to charity when he died. And the attorney told him, "Well, we're going to write you a trust, and it's all good." And one of the things the attorney says, "Well, now we need you to transfer your house into the trust." Attorney actually drafted up a transfer deed, a warranty deed. I I don't know what they were looking at, but this guy had already transferred his house. He'd already put it in joint tenancy with other relatives, uh, and joint tenancy with right of survivorship. And those people had no interest in letting go of their ownership of that house, letting him put it in a trust over which they had no control. And this is something that is so simple, but nobody bothered to go to the trouble to kind of dig and find these answers out. What kind of relationship do you have with these people? Why is this? Why is that? And so, yeah, his estate plan isn't going to work the way he thought it was going to. Uh, and he didn't get good counsel, and you're not going to be able to assist your clients achieving their goals without truly understanding them. That's both ethics and good business, in my opinion.
So we today, with this portion of the presentation, we have been exclusively really speaking about living trusts. What provisions are in their trust, where they come from. It's certainly something to mention, not just to state that it's customary and best practices, I would argue at least, that a living trust portfolio, I'll call it a portfolio, should include other documents other than the living trust. And so, so we have the trust, and we've described that a little bit. Typically, what goes with the trust portfolio is going to include what we'll refer to as a pour-over will. So, what is a pour-over will? A pour-over will is a will that has that usually has a specific function, and reasonable minds can differ on whether to do this or not. But typically, a pour-over will simply states that if there's anything not in my trust when I die, I want that transferred. If there's anything in my if not in my trust when I die, I want it transferred into my trust. And it specifically names the trust. Sometimes we'll name the personal representatives of the pour-over will. Sometimes we'll just say my personal representative is whoever the active successor trustee is, my trust at that time. But it's a fairly simple, straightforward document that is there. And I tell people, when I describe to people, I say it's really primarily serves one, maybe two functions. One is it's kind of a backup. It's kind of a backup to things, so that if like I said before, if something's not in the trust, it's there to put it in there. And I often will give a couple examples. Let's say, God forbid, you die in a traffic accident and your estate has a claim against whoever caused the accident. Well, that's a claim that's outside the scope of the trust. And so you want to have a will so somebody can pursue that. And the pour-over will
Can you go give
says,
this to the chickens?
somebody needs to mute themselves, please. Anyways, what I was saying is, you want to have the ability utilizing the poor of will to pursue that claim, and the poor of will is going to say that any claim would be poured in to the trust and distributed in accordance with the terms of the trust. Other parts of a good estate planning portfolio would be a living probate, tools, so that that can be used while people are still living, but maybe not themselves, not able to handle certain things themselves. So, as most of you probably know, I'm referring to um, uh, uh, general financial powers of attorney. So you can appoint someone to handle your business affairs, healthcare powers of attorney, healthcare directives, healthcare power of attorney, mental health care power of attorney, living will. These are all usually part of an estate planning portfolio. So, and as lengthy and as detailed as the different provisions are in a trust and even some of these other documents, this is what the questionnaire usually consists of. The variables in most cases, I mean, certainly a trust, a will, even sometimes the powers of attorney, the various powers of attorney or healthcare directives can be complicated. Um, for most people, the variables are very few. And I don't want to minimize the importance of the documents, but the variables, if you're using a good software package or good templates, the variables are names and addresses. I mean, that's that are plugged into a lot of these things. So in this case, if you can see what I have up here that I'm sharing with you, you've got the name of the trust or trustee. Let's, for our purposes, let's just say husband's name, their, cell phone may go in, their address may go into some documents. I know there are many document preparers and probably attorneys that don't put certain things in the estate planning documents, like addresses and phone numbers, because they change so much. But that's just kind of your preference. Who the successor trustee is going to be. You probably want to have, two or three backups. And it's totally up to the client what they want to do, but it's often probably a good policy for people to have individuals serving those roles and not necessarily jointly, although many clients will want that. I want all three of my kids as my successor trustees. The question is, whoever you're naming there, are they alternates or are they co-successor trustees? Can they each act independently, or do they have to act jointly? And then, this is an old questionnaire that I used for many years. There's a variation of one that I use now, but the pour over will, instead of rewriting everything, I just have people check a box. Is this the same people for your personal representative of your pour over will? Who you want to name for guardian over any minor children, and do you have alternates? If for the agents, for your attorney in fact, for your financial power of attorney, your healthcare directives, is it the same people we just listed above? If so, just check a box. Then we get into the contingent beneficiaries, or the beneficiaries of the trust. So do we have any specific bequests? Do we have any specific distributions that are going to beneficiaries? Like, my son will get my house in California. My daughter will get my house in Arizona. And for those specific bequests, what happens to that person that does not survive you, or does not live enough to receive their entire inheritance? Who would be their alternate? Would that be their children? Would it be somebody else entirely? Would it be their children and then the other beneficiaries named in the trust as second alternates? And so once you have the specific bequests dealt with, then what happens with everything else, which we refer to as the residuary estate? Who gets the residuary estate, and how is that distributed? And so it might, often it is just as simple as, I want my residual estate divided in equal shares between my three children, per stirpes, meaning that if they're not alive, it would go to their children. or per capita, or however you want to refer to it, to the other surviving beneficiaries of the estate. So it is pretty straightforward. However, with beneficiary designations, I would say I often, with some people, I shouldn't say often, but with some people, it's like pulling teeth to get them to tell you who they want to leave things to, and especially who the alternate would be if that person didn't survive them. And that's one thing I frequently, get questionnaires back where they don't give that detail. We want to list all their children. And then the rest of this questionnaire really just talks about different assets they have. So I know about all the assets, real estate, financial accounts, insurance policies, retirement accounts, chattel property, like vehicles, boats, so on and so on. And so we know what we have to do, because as John said earlier, the trust can only deal with what it owns. So we got to make sure that if they don't have some other way that they're distributing that asset, that it can be dealt with by the trust, either by titling in the name of the trust or naming the trust as a contingent beneficiary. I find nowadays that often people are not putting bank accounts like savings, checkings, money market accounts in the name of the trust. A lot of people are naming the trust as a POD or a TOD, a transfer on death. And the reason for that I get from people is that it's just too much of a headache for them at this time to change everything. And what I mean by that, and every bank is not like this, but a lot of the banks will require that they just open up a new account rather than changing the details of their existing account. So all the direct payments they have, all the, if they have direct, deposits, that has to be changed. And for some people, that's a huge deal. And so they just don't want to deal with that, at least at first. So anyways, that's a good example of the information that we have to get, how we get that information. Again, it's my policy that I have people fill out these questionnaires best that they can. And I'm not ridiculous about it. If I need to sit down with somebody, and sometimes you do, and fill it out with them because they're just not getting it done, or they're not comfortable doing that, certainly I'll do that. But I prefer to have people fill it out in their own hand with their own pen, so I can show that this is the information they gave me, this is the direction that they gave me. Anything to add to all that, John? I know I went over that kind of fast in the interest of time. You're muted, John. John, you're muted. John, you're still muted.
I'm sorry. Can you hear me now?
Yep.
Apologize. Yeah, I think that a questionnaire like the one that you just put before us, and that I know you're going to include in the handouts, is an excellent template to get to know your customer. And the more you know your customer, particularly in a trust scenario or an estate planning scenario, the better job that you're going to do. That's both ethical as well as practical. Also, I noticed a couple of questions in the chat that I thought I might address real quickly.
Okay.
Suzanne asks about irrevocable trusts, and specifically, it's her understanding that Medicaid recipient or an All-Tex recipient cannot, the state cannot attach a lien to the trust, and yeah, that's true. But understand that if a customer comes to you and says, "Oh, I want to set up an irrevocable trust so that I can qualify for All-Tex and then not have the state attach it," that the state will do a pretty thorough application process, and any monies that are transferred to such a trust within 5 years prior to the application process the state will count that as assets against the client, even though they don't have them anymore. They don't own them. They transferred them. It's irrevocable. the state will still count those assets as if they had them for a period of 5 years, and thus prospectively deny the ability to qualify for Medicaid or All-Tex, or potentially disqualify them from Medicaid or All-Tex for that 5-year period. So just kind of and there's a weird little sentence in the statute correcting that says that anybody who assists or advises someone to hide assets for the purposes of qualifying for All-Tex can be held criminally liable. And I don't know about you, but I ain't in this business to be held criminally liable. So I don't, someone that thinks they're going to hide assets to avoid All-Tex or Medicaid, maybe they're not your customer. But at the same time, yes, once those 5 years have passed, I'm not going to say they're home free, but yes, then the answer, Suzanne, is yes. A little further, Beth asked me about business trusts, and there really is no such thing as the category of a business trust that I know of. A trust is just what we said at the beginning, where the state statute sets out the requirement for the trust, that there be a settlor, that there be a trustee with known purpose, and that there be a beneficiary. And that beneficiary has to be a flesh and blood person, identifiable. And then there's a couple of exceptions. There can be a charitable trust, so the beneficiary can be a charity, and a pet can be a trust. And so, yes, a charitable trust can be established, property transferred to it for the benefit of a church or something else. That's not by definition a business trust. That's by definition a charitable trust. A little further along, someone says that with a pour over will, the trustee found that there was a bank account that had not been retitled to the trust, and the bank wouldn't honor the pour over will. And yeah, that's correct. The pour over will is there as a catch-all in case assets don't transfer. The pour over will isn't an instruction to the bank, but it's rather a document that can be presented in probate. And again, there's a couple of different types of probate here. If there's less than $75,000 worth of assets, then there can be an informal or streamlined probate by affidavit, in which case then one doesn't have to open a normal probate case and run through all the hoops that go with that, but very simply type up a one-page affidavit and give it that meets the requirements for the statute and present it to the bank, and then they will release the funds. But if that bank account had more than $75,000 in it, no, they're going to require a regular probate, and you're going to have to run it. But at least the will says who the heir is. The heir is the trust. And in the absence of there being a will, then the trust wouldn't be getting that money. The Arizona default statutes would kick in. And I hope that's kind of helpful. But I've done several probates where just that exact thing has happened. And in my case, the ones that I'm thinking about two of them. One where the decedent had a money market account that had about $85,000 in it, and they never bothered to retransfer it to the trust. And because it was over that 75,000 limit, we had to open probate. And I had another one where the guy was a businessman, and he had his business account, and it also had, his was real close to the line. It had like $76,000 in it, and he died, and his wife couldn't get at it. We had to run probate for her just to get that account. And so, yeah, that's it. But if the account had less than 75,000, or if the total amount outside of the trust was less than 75,000, we could have grabbed it via affidavit with just a simple one-pager presented to the bank. Hope that helps the people that ask those questions.
Yeah, I want to add just an unfortunate and, in my view, an unacceptable reality with some banks is that they don't know what the heck they're doing sometimes. And I don't like disparaging the bank, but I've just seen this too many times where they just don't understand. And even the ones where, like Chase Bank, for example, I think they send everything to wherever their legal department is, and wherever, I don't know, and in Czechoslovakia or wherever it's at, and then they have, and then they wait a few days and they get an answer back. And I just think, if I'm assuming that the question came from a situation where, let's say, there was under $75,000 in that account, and you could use a small estate transfer affidavit with the pour over will, that should work. There's no reason that shouldn't work. But unfortunately, sometimes they just don't understand, and that it can do it, that it can work like that, and you're stuck doing some kind of probate. But hopefully that's not it. But all right, one more question, and then I'm gonna go on to the last segment. Susan, you had a question?
Yes, actually, it's more of a kind of an information. So I ran into an issue with a will. I had one of my clients who died, and her beneficiary has done everything that she's supposed to do, including like closing out her cell phone and her power and all that. Well, they got these refund checks from the utilities. The problem is she couldn't do anything with those checks
Right.
without probate. So I talked to one of my friends that works at the bank, and she suggested that if you're, whoever your beneficiary is going to be, and this is on a will, if you're in a trust, it's fine. But if you have a will and you've set up like a POD, that doesn't allow them to put money in the bank. That just allows them to get it out, is to open up a small account and name them as a joint person on that account. So you and whoever your beneficiary is going to be, and keep it open until all those payments have come in, and then you can close it out. But this poor lady had like $250 that she had to turn around, give back to the electric company and the phone company or whatever, because she's not going to spend the money to go through probate to get that $250. So just something to be kind of aware of. And I never even really thought about that.
That would be a perfect opportunity to use the small estate affidavit and turn around and ask them to rewrite the check to the sole beneficiary using that small estate affidavit without.
Yes, I did suggest that to her, and she did try. I gave her the affidavit. She got it filled out. We notarized it, and I don't remember which company it was. I don't know where it was, Arizona Public Service or one of the phone companies, T-Mobile or whatever, wouldn't even accept it. Even with a death certificate, even with all of that. So yeah, sometimes, and like Don was saying, banks, they don't want to look at the small probate affidavit or that small estate affidavit if it's less than 75,000. They just want you to go get letters. They don't even want to mess with you.
I've fought that with the banks myself many times, and I would suggest to anybody listening that the branch manager in the bank is supposed to be the most educated one, but they're not. Certainly the loan officers or the floor officers or the teller line doesn't have a clue. And you just have to be very patient and not blow your cool, and try to get it elevated, like Don said, up to the legal department. And then hopefully you can get in touch with them and help shepherd it along, because then they can always be sent a copy of the relevant statute from Arizona, which I've had to do. Wells Fargo, I've had to send the stupid Arizona statutes a couple of times, and you just have to be patient. Yeah, that happens. Be prepared for it.
So I'm going to move on to the last segment, which we only got about half the allotted time for, but I mean, as far as I'm concerned, we've already had an hour of ethics with the other stuff, that with the other stuff that we've gone through. But I'm gonna go through this last segment, and I will end just after one, probably just a little bit after that, and I'll give the final verification word, and we'll go from there. So. This, I've been, as I mentioned at the beginning of the class, I really have, whether it's been successful or not, I don't know, but I've really tried to be a little bit more creative with the way we talk about ethics and not just have the same, a review of our code that we've had probably in the first 15 years of our existence. And so anyways, with this one, and I don't know if I have time for this, but I was hoping to find 3 volunteers that might help me with this first part, where I wanted you to talk maybe about a typical customer, or that you have come in family law, probate, immigration, or estate planning case. And I guess I'll be my own 3 volunteers to expedite this. But my point is that I would imagine that whoever would have participated in this would have talked about how your typical client that comes in, regardless of the area of practice in, family law, probate, immigration, or estate planning, they probably don't know a whole lot of anything about the subject matter. Their knowledge and their experience, is limited to none. Of course, there are exceptions to that. More than that, often depending on what the category is, what they're coming in to do, they may be in a state that is not really helping them utilize their executive functions of their brain very well. In other words, they're upset. They're grieving. They're confused. I could go on and on. And so, that is a challenge to us as document preparers, as professionals, that have, very strict limitations or parameters, I should say, around how we offer the services that we offer. And so, our primary objectives in providing a good service, in providing, the service that our clients are looking to do, giving the information that we need to give to the client so they can make the decisions on their own and direct us on how to provide the service to them. And ultimately, those are objectives, and then ultimately is having happy clients that are going to come back and maybe refer other people to us so that we have a successful business. I mean, that's let's be honest, that's what it often comes down to, and you can put your importance maybe a little higher with one thing or another. But my argument is that, or this presentation, I should say, is about utilizing, having an ethical approach to customer service and how that can help you meet and exceed your ethical obligations of the CLDP code. So, we're going to go over a few things about ethics and about some skills, soft skills that I highly recommend if you already don't focus on them, that can really make this happen in your world with your clients, can increase the likelihood that you're going to be doing things that clients want you to do, that they can communicate with you what their needs are, that you can communicate with them what options they may have, generally speaking, and how they can engage with you to meet whatever their legal goals are. And so I'm going to go over also with that some kind of what I refer to as universal moral standards that apply to ethics. And then again, I'm going to talk about some of those essential customer soft skills, so to speak, that you can use, mostly communication skills, but other skills as well. So let's talk about a couple definitions. So when we talk about customer service, I mean, that's kind of a no-brainer to know what that is, but I feel like I always like clarity. So my definition here is it refers to the support we as CLDPs provide to clients before, during, and after the customers purchase our services. And such services might be answering questions about CLDP services, helping customers find solutions to their legal objectives, their legal dilemmas, performing our services and delivering our services in accordance with 7-201 or 7-208, both of them, and answering everything from their questions to customer complaints and following up on their issues. So that all, and I'm sure much more for many of you, encompasses customer service. Now, what are we talking about when we're talking about CLDP ethics or ethics in general? Of course, we're talking about those moral principles and policies and values that govern the way we as document preparers approach and engage with in LDP services and related business activities with our clients. And so, as I mentioned, today we're going to be doing more of a deep dive into ethical practices that kind of go beyond the basics of our CLDP code and that can help us build trust with clients and make our practices more successful. So, why is all that important? And I realize there's a lot of overlap. There's a little bit of a redundancy of what I'm talking about here, but having those ethical customer practices help us form stronger partnerships with our clients, allow us to, engage in clear communication and a shared goal of achieving whatever our clients' outcome should be. And it puts everybody at kind of a level playing field. So you're not there necessarily as they're, in a dominant position over them, or a subservient position, or the other way around. You're there working together, which is the way it should be. Albeit you have the expertise of being a document preparer, it's a collaborative effort. And I think I've mentioned in past classes, from my perspective, I think we have a much more difficult job with clients because we have to constantly educate them in such a way that they can tell us what to do. Attorneys don't have to do that. They just tell them what to do. We have to constantly be educating people on what to do. And so having high ethics, using some of these universal moral codes is critical in providing our services. So, and in the end, just that, we're left with customers, hopefully, if we engage in these ethical practices that feel that they're acknowledged, they're valued, and they're well informed. And you're not going to have, regardless of what happens with your client's stuff, you're not going to have, you're likely to have a complaint when you've engaged in services in this manner. And here's just kind of a list of, and these are no-brainer things. I realize that, but they really do directly relate to, if we engage in this kind of behavior, if we adhere to these moral standards, we are going to meet and exceed our ethical obligations as described in the CLDP code. So if we're trustworthy, we're honest, we have integrity, we have reliability, all those things directly relate to our obligations in the LDP code. If we treat clients or customers with respect and dignity, I think, is a big thing that is lacking in some cases. We're responsible and accountable for our own actions. We're truthful. We don't lie. I already talked about that, but I think being truthful is sometimes a hard thing to do when you've got 100 cases going at any one time, and you may drop the ball on one thing and it's late, or it's not delivered in a time or manner as you promised. Sometimes it's much easier to not be entirely truthful, and that can really come back to bite you. But you engage in fairness with your clients. You express a certain level of caring about your clients. So as I mentioned, that just kind of that relates to the CODP code. If you follow these moral standards, you will meet your ethical obligations without a doubt. And I have some of them listed here, just avoiding the appearance of impropriety, you being alert to conflicts of interest, all those following those moral standards help you be more aware and help you meet those obligations and exceed those obligations. So let's talk about some customer soft skills that I think are critical in our practice and that can really help us improve our relationships with clients, get client referrals, provide a better service that is more in line with what is in the client's best interest. So, talking about empathy, talking about having patience, which is a hard thing to do sometimes, talking about having strong communication skills, using certain communication skills that I'll get into. So, why is that important? Why is that necessary? I've kind of already mentioned this, is because we have a client that comes in with no experience in what they're doing. They don't want to be there. They don't want to be often in part of whatever procedure they're having to engage in, especially if it's something like probate, if it's something like family law, if it's guardianship of their incapacitated parent. There are just so many reasons why they don't want to be there, and they are not in a good state of mind to adequately instruct us on what should be done in their loved one's best interest, or whoever they're dealing with. But who has clients coming into their door that are in a state of mind as I've described here? I've just listed a number of them. They're afraid, they're angry, they feel resentment. They're in a state of denial because of a loss of a loved one or a loss of a relationship or what's happening with their children. They're grieving to some extent. It can be a very grim situation with the average client that comes in. So you would really benefit by focusing on certain skills, soft skills that can help you deal with them and understand them. We talk about empathy, and a lot in some of the CLE classes that I have taken, utilizing empathy in your daily practice. And what's that about? It's about putting yourself into somebody else's shoes, feeling what they're feeling, understanding what you're feeling. It helps you read between the lines to understand what's really helping the customer or what could really help the customer or not. Certainly requires emotional intelligence, the ability to read other people's mental and emotional states. I'm going to give you a little example that hopefully this works, that I think is a good example, a good explanation of, oh, and we have a commercial first. Gives you a good example of what this means. Is nobody able to hear the video? John, can you hear the video?
No volume.
Oh, has that been for the entire video?
No, I have not heard any of it.
Oh my goodness. I apologize.
Been reading the
Uh,
subtitles.
All right. You know what? It might be because I still have John spotlighted. If you,
Get rid of me.
I just did. All right. Well, let me see. If somebody would, after I turn this on again, if someone would tell me if they can hear the audio, I appreciate it.
Still nothing. Still no audio, Don.
Okay. Well, we'll skip this. Oh, what a bummer. I had a couple little cute videos that made some points, but that's okay. All right. So, we talked we talked a little bit about empathy. These are some examples in empathic statements that you might, use. And there's the silver lining is we read the subtitles. Okay, I appreciate that. Here's an example of some of the empathic statements. This gives you an idea about how to make them, and they can help show a customer that you understand and you care about their situation, but you're reflecting the emotion really you see in what's going on in their life. So, I can understand how frustrating this must be. I can understand how you don't have much time. Your feelings about this are completely valid. And a lot of these kind of techniques, these using empathic statements, they seem a little cheesy, they seem a little corny, but they mean the world to people, and they can really help people open up to you. I have a lot of experience in that in mediations that I do on a regular basis, and utilizing some of these communication skills can be just key in opening people up and getting them to move towards communicating, towards a resolution of conflict. All kinds of benefits. We should be aware of our biases, how it can interfere with your ability to listen and empathize with your clients. Also, always check yourself when you're in a situation with people, especially if you're dealing with a lot of emotion with somebody. You're dealing with somebody, let's just say, by example, somebody that's going through a probate and they're grieving. And maybe you have had a similar experience. Be aware of how your client's experience and your client just in and of themselves might be impacting your ability to provide your services. And make sure you check that, make sure it's not, making you biased in some way that you can't provide your service as well as you otherwise could. Clearly communicating. We have to provide information to clients that can be very complicated. So making sure that when you do that, you break down the process, you divide the legal process into manageable steps, you explain steps sequentially, highlighting key actions or key timelines. Probably many of you, I always did this not with everything that I did, but with family law, I always did. I always had, simple but detailed outlines of the process that people could go back and refer to over and over and over again. Providing context, in dealing with people and explaining the process in a way that they understand and how it relates to what they're trying to do, using analogies or examples to make abstract concepts more relatable. And of course, being concise and clear. these are some of, I know we're almost out of time, we're almost done, but using communication skills like active listening, reflective listening. Again, for a lot of people, even people in our business, it can seem a little cheesy to use these skills, where you're paraphrasing people, you're restating main ideas in your own words to show that you understand. You're summarizing their main points. You're paraphrasing. You're engaging in reflective listening, which is kind of the same thing as paraphrasing, but adding the emotion that you're seeing to it. It connects you with the client and gets them to open up more to tell you what you need to know so you can help them. I'll tell you, the biggest problem I think that people in every profession really, that a customer service related professional, the helping professions, for example, I think the biggest problem that the average person deals with is getting out of your own head and really listening and not being not just sitting there thinking about the next thing that you're going to say. In my work as a mediator, especially, I completely focus, well, probably not completely, but I make a great effort to focus as much as I can on only listening to what they're saying. Because otherwise I get ahead of myself and I inevitably reach some kind of impasse with them where we can't move on, or I don't understand the circumstances well enough to facilitate the discussion. Okay, so yeah, again, I had a video for that. I'll send this to you. You can watch the video that gives example. It gives great examples of using active listening in your in an interaction. Using patience, and again, being patient with somebody. Use positive self-talk to yourself so you can adjust your own attitude. Know your triggers, kind of knowing yourself, being aware of what, if you're negatively triggered about something that's going on with the client. Again, engaging in active listening, making sure that you're meeting with customers in a place where you're not going to be interrupted, validating the customer's feelings and demonstrating empathy, maintaining a common professional demeanor. These are all things that we already know, but every once in a while we need to stop and think about these things and make sure that we're utilizing, patience in meeting with clients. And, as I have a list of benefits, I'm sure there's many more. You're going to keep that client. That client's going to be loyal to you. Or if there's a problem going on, by engaging in patience, you're more likely to de-escalate that conflict. You're going to have better communication. You're going to have an improved customer satisfaction. I don't know how many of you track those kind of things, but I can almost guarantee you, if you utilize these communication skills and you're tracking your customer satisfaction, that rating is going to go way up. Now, the rest of this are just, and you can read these on your own, but I had some reflective listening exercises, just, statements that people might say and your reflective response. This is all about practice. We're not born knowing how to communicate in this way, but there are many, videos, books. There's a lot of stuff online that can help people improve their ability to communicate, improve their ability to utilize these communication skills, which again, in my view, will always improve the quality of your business, improve the quality of your work, because you're understanding people more and they're understanding you. Any questions, comments about this category? Okay. And I'm sorry I had to go through that so fast, but I think we had great presentations today, and so it was worth spending the time on some of the other stuff as well. So the third verification word is dream. DREAM, dream. So write that down. Hopefully you've written down the other two verification words. please send those verification words to me, either in response to the last email I sent you about the class or just independently. And I will respond to you. I will probably not be doing that today or tomorrow. Probably Monday and Tuesday, I'll be sending out the all the certificates of completion as well as the handouts. But any questions, any comments? Let's see, I'm looking through our chat. I'm not sure if everything was answered. Okay, the one question, off topic continuing education question, can we do 2 5-hour webinars to satisfy our annual CE requirements, or does a portion of our require have to be in person? My understanding, and you can call the program to confirm this, but my understanding is that a live action webinar is the same as in person. That's what I was told. And so, you know, having said that, the next 2 seminars that we're going to have are going to be in person, and I would love to have all of you there. So hopefully that will happen. But yeah, I'm just looking for any other questions. Nope, I don't think so. So if there's nothing else, then that would conclude our February webinar. And I thank you all for coming. I hope you learned something, got something out of it, and you are free to go at this point. Yeah, but I'll stick around for a while. If anybody has any questions, raise your hand or just speak out, you know, and we'll talk. But I'm going to be here for a few minutes.
Don, I have a question. This is Bernadette.
Sure.
For purposes of a will trust, is it your understanding that an order of legal separation does mean the parties are still legally married?
Yeah, they're still legally married, but is your question, how does that impact the existing estate planning documents?
Right. So one person decides to do a trust to separate assets. Are they listed as a married person?
Yeah, I know when they're divorced that actually once when they're divorced, I know that changes the character of those documents. John, you want to answer that?
Yeah, can you hear me?
Yeah.
Yes.
I was busy. I was just getting ready to go to the statute to answer that question. The fact of the separation will have nothing to do with the trust, because remember, the trust is a private arrangement, unless the trust has specific language that addresses that. With respect to a will, and by extension, your question may include powers of attorney. If the spouse is named as the personal representative or as the agent in the power of attorney, I want to look up when their power is terminated. The statute automatically terminates a spouse's power with divorce. But your question was, does it automatically terminate with legal separation? And I don't know that answer off my head. I was going to try to look it up. I do know that when I write my documents for clients, that I actually include a clause in it that says that legal separation will invalidate the appointment. So that's kind of how I get around it in advance, but I don't know the answer without looking it up.
Thank
Okay,
you. That makes sense.
All right.
So I got halfway there with you.
If you want to send an email to me, or I don't, you know, I can try to find the answer, a more definitive answer to that question for you.
Will do. Thank you,
Okay.
gentlemen. Thank you again.
All right. Thank you. So John, you got a busy day?
I have lots that I can do. My expectation was to put in about 2 more hours in the office and then go, but I don't know. We'll see.
Okay. Oh, I wish I had more time to do that last presentation. I was nervous but looking forward to doing it because I had a couple other videos connected, very short ones, like a minute, connected with it that were kind of funny from some, popular
Yeah.
shows that demonstrated poor communication, good communication, but I don't know. I got through it.
Yeah, we did. There's always more material than there's time for.
Yeah. Yeah.
I don't know the answer to that question.
You know what? It wasn't, I can't remember why I did this, but it wasn't that long ago that I looked up that statute. But I don't know what it was for or what
Oh,
it, what
here,
it,
here, 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 here. I
okay.
found it. Okay. Oh, okay, here it is. So this is in the effect of a divorce, annulment, or decree of separation on a will. A person who is divorced from the decedent or whose marriage to the decedent has been annulled is not the surviving spouse, unless by a subsequent marriage that person is married to the decedent at the time of death. A decree of separation that does not terminate the status of husband and wife is not a divorce for purposes of this section. So
Right.
it does
what
not
I thought.
extend to separation. So in that case, the will is still valid, and that surviving that person is still a surviving spouse. Now, what it doesn't say I don't think that would prevent if a will named a spouse as the personal representative. You got to remember that personal representative, that's only a nomination for personal representative. That personal representative still has to petition the court to become personal representative. So I don't think that even a divorce would necessarily prohibit a person from petitioning to become personal representative of their deceased ex-spouse's estate.
Right. Yeah, it wouldn't, because if it doesn't invalidate it, why then it shouldn't prevent that.
Well, and yeah, because but the question was what happens with a separation, and the separation does not change whether a person is a surviving spouse. So I don't think a separation would, if affect anything here. I didn't, now that was specific to wills. I didn't look up powers of attorney.
Oh, yeah.
Right? So, and certainly it will have nothing to do with the trust. If they're going to get divorced or separated, then they need to amend their trust.
Right. Hey, thanks for all your help today, John. I really appreciate it.
You think it was helpful? You think it went okay? I was winging
Oh
it.
yeah, I think it went great. I think we could have done 2 hours on those slides that we had there.
We almost did.
Yeah, we easily could have done 2 hours. It's sometimes it's so hard to gauge. I've never. That's one thing about doing these, doing any seminar or webinar. I always have a tough time gauging how much time I need or have, how
Yeah.
much time, that it's going to cover.
I similarly have that same challenge. And by the way, I really enjoyed Nicole's presentation.
Oh, she is polished.
And I thought, I have a business and my plate is pretty full. It's very full with the things I do. And then after listening to hers, I thought, I wouldn't mind trying that. I wouldn't mind doing guardianships. And then I'm thinking, oh, well, for heaven's sakes, where are you going to find an extra 5 minutes to try to learn and do a guardianship? I just think it would be fun just to have the experience of doing it. So, I'm sick of writing wills and trusts. So maybe I should just quit that and start doing guardianships to do something new.
Look, Laurentina, did you have a question?
I have a suggestion. Do that. I'll call it a newfangled thing. The TikTok talks. You just sit there and talk for half an hour. And
Yeah.
then click on it, and I'll just sit there and listen. You guys have years and, well, I'm not going to say years and years and years and years of experience, but
go ahead and say it. We're old.
Speak for yourself.
Okay. But I don't know, and I'm also a geek, so I love to, even that 3-hour class or presentation somebody gave a few months ago. I remember it was so boring, but I learned so much. And I usually, if I have to walk away from my phone, which I'll just pause it. And I did, I paused it and rewound and kept listening. It took me like about 2 days to listen to it. I listened to it several times because I'm never going to do that, but I have now I know what happened, why it happened, and you're screwed, can't do anything about it kind of thing. But I was just going to say that maybe you guys should do those little podcast things that other people do.
No, it's a great
She
idea.
called us boring, Don. She said that we were boring. I heard
No,
her
that
say.
one lady would, and it's not that it was, the subject matter is a little bit boring. Just because it's so tedious and intensive, but it was still good. I listened to it. I had to pay to listen to it later or something, so it was an old one, but it was last year sometime, and I got my car cleaned and I got educated. And
Well, you know what? That's a good way to do it. But you're right. We should take these and make a library and leave them online for people to look at anytime.
Yeah. No, you're right.
So it's okay. You don't need to give me credit for that once you do get started. But when you retire, we don't know that word. But maybe if you're not doing anything while you're driving to work one day, you can pop it up and do that.
Absolutely. It's a great idea.
All right. Thank you.
All right. Have a good
Thank you.
weekend. All
You
right.
too.
So I'm going to sign off now too, I think, John. So have a productive day. And
Thank you, sir.
again, thank you for all the help. I appreciate it.
You betcha. It's a
All
pleasure. Thank you.
Bye-bye.
Let's see.